Actually, 7:02. This meeting tonight is in regards to the sheriff's position. What we'd like to do is open this up for a little bit of discussion amongst the members. Just to inform everybody that we have received from County Attorney Jim Carroll, in conjunction with Dan Mullen, who is our attorney in the Supreme Court case, a little bit of background information for us all to read. I trust now that everyone's had a couple of minutes that they have been able to go through the packet that was presented to them, and I would like to open that up for discussion. Anybody want to start off? Representative Morris.
We are in an unusual situation in that we have been given by the courts some very specific information that, while not a statute, serves as the law of this case. This situation has been very specific. They've been very harsh with us. They have found us in error with all three issues, whether we could do this in non-public session totally. They said, no, the court was wrong, the trial court was wrong. Whether we could the two other questions were also found improper. The court failed to invalidate the selection of Williams as sheriff, and the court failed to provide access to re-air and failing to provide access to documents. They're basically saying that our process was flawed from beginning to end. I remember in 2005 having a discussion of this nature in dealing with Commissioner Bartlett's demise and how we were going to fill that position, and my feeling was that we were in violation of the right to know law then. We followed that same process again, and now we know we are in violation of the right to know law. What we come up with is something that is very hurtful to the person who was holding the position, or has held the position of sheriff in good faith. However, I see no way of dealing with this other than going back to the beginning and redoing the process, knowing we will come out with totally different documents, knowing that there is, it will be a different result in some ways. We'll be dealing with different materials, and we will conduct ourselves in a very different manner. But I don't see how we can, as Jim Carroll has said at some point, snub the Supreme Court of the state of New Hampshire by doing anything less than redoing the process.
Anybody else? Representative Thomas.
Excuse me. I've been away for a couple of weeks, so this whole thing, the decision of the Supreme Court, I've just received. I didn't get back till last night about 9 o'clock, but since then I've received 4 phone calls regarding the situation. And I'm going to go back, and I hope I'm not boring anyone, but I'm going to go back to the original process and seeing that Commissioner Bartlett's position was brought up. Back then, we made a decision as a delegation as to whether we were electing a person or whether we were filling an unfortunate expired term, if you will. And we made a decision back then that we were doing the latter. We were appointing someone to fill a vacant position. And this, to me, is the crux of the whole matter. It has been, this decision has been ignored by the legislature. And as far as I'm concerned, my opinion only, it's been ignored by the courts. Whether or not we are filling an expired term with an appointment, or whether we're electing someone. Now, the law says the county delegation will elect a person to fill that position. Now, that's all well and good, except for one thing. It does not say whether or not that position at that time is an appointed position to fill an empty spot, if you will, or whether or not it's an elected position. At that time, I'm not talking about the regular election process. At that time, no one has made that decision. So this is why we have, I believe, that we have acted the way we have. It is an appointed position. So therefore, that position, in my opinion, should be given all the same considerations that you would do if you were hiring someone. Therefore, that person's privacy as a hiree, if you will, should be protected. It is not the same as if it's an elected position whereby someone goes through the election process and therefore, if you will, their whole life is laid out on the line. And I'm talking about all of the applications, all of the resumes, and every other piece of documentation that goes along with it. And that has been in my opinion, that has been our problem all along, is no one has identified exactly what we're doing. If you remember, before the law changed and said that we, as a delegate, as a county convention, are the ones that appoint or elect or what have you, someone to fill that spot, that was done in closed chambers by a judge, and no one had any kind of input whatsoever on it, including us. Now, it was changed for other reasons, but the point of it is that is where it lies. Is it an elected position or is it an appointed position? If it's an appointed position, that person that fills that slot has got all the rights and considerations of privacy that any other employee would have. If it's an elected position, we have absolutely no right to usurp the constitutional rights of our constituents by not electing them or by standing in their stead to elect someone. So having said that, I'm trying to bring this down as brief as we can because we could be here all night. I think that if we decide that it's an appointed position, we should go about and doing that as if it is any other position that we fulfill as an employee, as we do the Gunstock area commissioners. If it's an elected position, then as The chairman and myself put in a piece of legislation last year that said that all unfilled terms will be filled by special election. We should not deny our constituents their constitutional right of electing someone to fulfill that position. And that is the way I feel. Any questions?
Thank you, Mr. Chairman. I respectfully disagree with both of my colleagues. I think you're both focused on what's occurred in the past. While I might agree with some of the statements that both of you made, the fact is we now have a court ruling. We've accepted it. We're not appealing it. We're going to do this in public session. It's academic, whether we're filling, electing, or anything. Those are not the words in the RSA. The RSA reads, if a vacancy occurs in the office of county sheriff, county attorney, registered deeds, or county treasurer, the members of the county convention shall fill the vacancy for the unexpired term by majority vote. That's the extent of it. There's nothing else. It does not tell us to what extent we must do, how much, what kind of process. Each time we've had a vacancy, and we've had an unusual number of them in Belknap County in the last 3 years, we've decided on the process at that time. And they range from fully advertising, looking for candidates, soliciting candidates, looking at who's in the office, looking at experience, and looking at our knowledge. So we need to establish how we're going to go forward. Nothing says we have to go back to repeat a process. We have to have a new process. And that's ultimately, we've got to fill that vacant position. I would hope we can accomplish it quickly. And that is simply for now until November, when the real process takes over. And we have already had the filing for that position. So let's forget the past. We're not going to, re-debate the case of the court.
Thank you, Mr. Chairman. I have just finally been able to review the Supreme Court decision as well. And I think, well, first of all, I guess that my general feeling in the matter is that we have definitely made some mistakes and we haven't taken the process seriously enough, but we did look for legal opinion, and there was a lot of diversity in that, and we did feel as though we were making a big step beyond when people went in front of a judge at the court and no one had a clue what was going on there. It was very recent really that the process was changed, so that these decisions were made by the conventions. But the fact that this was carried to the Supreme Court and they indicate that they are the final arbiter of the legislature's intent as expressed in the words of the statute considered as a whole. And the examination of that, they go through all of these cases that they have reviewed and looking specifically at the importance of the right to know law. For instance, I'll say when a public entity seeks to avoid disclosure of material under the right to know law, that entity bears a heavy burden to shift the balance toward non-disclosure. And of course, we realize that no vote while in open session is taken for a secret ballot. That's very clear to us now. But then that whole debate about whether we're hiring someone, whether they're being appointed. It's humbling to me that they actually refer to Webster's dictionary. And they are trying to use language that is ordinarily understood and not trying to put additional thoughts into the minds of the legislators back then when that was put there, or to add additional words and that kind of thing, trying to be very clear on what was meant. And the convention is not hiring or engaging in personal services of that applicant can run from a privileged to some. The convention is not hiring the applicant for the office of the sheriff, but instead designating an applicant for placing an applicant in the vacant office in lieu of an election.
and as such is essentially appointing a person to the office. Because the trial court did not cite and the respondent did not offer any other exemptions supporting the notion that the convention could have filled a vacancy in the office of sheriff in non-public session, we conclude the convention was required to fill the vacancy in the office of the sheriff in public session. And it goes on really to deal with the whole process in that the public's right to know outweighs the participants, those who put in their applications, it outweighs their right to privacy. And it has just reiterated that over and over. And because they have actually taken the position that that the sheriff is no longer in place as a sheriff. He has been temporarily, well, we don't know temporarily, he's been removed. We have someone else sitting in that position now. So I kind of initially, I'm sorry, I thought Lieutenant Christoph was taking the, he's active, all right.
Let's keep this right now for the delegation. You'll have your opportunity.
Well, so, and then part of this is saying we must not consider whether the trial court properly declined to invalidate written selection of the sheriff, despite the conditions of the ballot, because the court may invalidate the action. The general statutory construction of the word may is permissive in nature. Generally forbidding secret ballot votes during open session, RSA 91A2, Section 2, the legislature clearly evince its intent to allow the public an opportunity to know and scrutinize the actions of its governmental officials. Public body is appointing an individual to fill a position normally filled by an elected official. The reasons for allowing public scrutiny of the actions taken are even more compelling. And then they also cite the fact that 4 representatives voted against the selection of regular sheriff and 1 representative abstained from the vote altogether. In these circumstances, the public's need for scrutiny was critical, since there was no other manner in which the members of the public could determine how their representatives voted. Such that they could then hold the representative accountable.
Excuse me, just for a second. Did it also say that there were 9 people voting in favor?
Well, it doesn't really specifically say that, but it's mostly just, it's not suggesting that we didn't have a reasonable majority in the decision, or that the decision wasn't a good one. But it was the process by which we didn't let the public in on what was our thought process. Why did we vote a certain way? What questions did we ask when we interviewed them? And I will admit, I was one that felt that we should allow privacy for those initial people coming in. And this has made it very clear that that was a wrong thought process. And it's unfortunate that it's taken us to this extent with, I can't help but think of whether it's $50,000 or whatever, that could be helping people with, put oil in their homes instead of doing this. However, for the democratic process, this whole right to know issue is very, very critical. And I think that we're at a place where we need to be very careful on how we proceed from here on out. And I think that we need to have the 7 people that originally came before us have the opportunity to come back and sit here again and have the whole thing revisited so that people can see who they are, look at their resume, understand the questions and the answers that are there. I don't think that we can reinvent that otherwise. I don't think we have enough paperwork that we can say, well, these are what questions we asked, these are how we answered. If we can put that together and put it out there for the public, then I think that's great. But I'm not sure that we can do that. I think we're going to maybe have to provide an opportunity to redo from that point and then bring it forward to the end of the process.
Have you had an opportunity to read the letter from the county attorney?
I was just trying to read it when I sat down, and I think there are certain thoughts here that are different from mine, and I'm certainly not an attorney. I have the benefit of having a husband who's an attorney. I have certainly talked to him about it, but we only printed this thing out early this morning, and I read it myself through the work day to day, and it just seems, where they talk about a three-step analysis, considering whether disclosure of public records constitutes an invasion of privacy, and the three ways in which they are evaluating the public interest in disclosure. They talk about the sheriff being in a position of the safety of the public, and it's a highly critical position in which people should have an understanding of the process. Here's his finally, in balancing the foregoing interests, we conclude that the public's interest in disclosure significantly outweighs the privacy interests of the candidates. Because the office of sheriff is an elected office supported by public funds and upon which the lives and safety of the public depends, the public has a vital and obvious interest in the background of all applicants, not just the candidate finally selected by the convention. And the final thing that I had highlighted, we therefore remand for consideration of whether, in accordance with the principles outlined above, any personal information will be redacted. But on remand, the respondents being us bear the burden of identifying specific information, if any, that they believe requires redaction, and demonstrating that the interests of the candidates and government in non-disclosure of such information outweigh the public interest in disclosure. So I don't know, I guess we would have to look for the resumes and see if it was something that should be redacted, but.
And we've already done that.
So I think that they're generally putting in their application, understanding that this is a political position.
Well, I want to read the letter from the county attorney that was presented to us, and I apologize for reading it, but I think it's important enough that we do read it. As I see it this moment, it's addressed to myself and the convention members. As I see it at this moment, I believe that you have two choices of interpretation. First, I believe you have the statutory authority to proceed to fill the vacancy, unexpired term by majority vote, pursuant to RSA 66191. Your methodology in proceeding is that fashion is entirely yours to design, including but not limited to proceeding with a vote this evening, or this night, excuse me. In this analysis, by virtue of the court's invalidation of the appointment of Craig Wiggin, I believe that you can proceed as if it were a new day. Secondly, in the alternative, you may decide to proceed as if this process that was initiated by you in posting the vacancy in the past is ongoing and is continuing to date. In that process, the court has issued an opinion to which I am of the opinion that you have complied with to the extent possible. I've analyzed the process below. I have attached a copy of my letter to Mr. Tardif and Lambert. The convention, through the convention's clerk's office, has provided documents of the candidates pursuant to my letter. Those documents were further supplemented this morning to include letters of recommendation for the candidates. During the course of the meeting yesterday with Mr. Tardif and Lambert, the minutes of the non-public session were requested and discussed. The regulations for such a disclosure are same as contained in RSA 91A33. Minutes of the proceedings in non-public session shall be kept and recorded, of all actions shall be promptly made available for public inspection except provided in this section. The minutes lacking in compliance with RSA 91A have been provided to Mr. Tardif and Lambert. Those minutes of July 11, 2007 are attached.
No.
Excuse me. Are attached. I have confirmed that those minutes are the only minutes available. The interviewing of candidates should not have occurred in a non-public session. The court has indicated specifically that the convention analyst analyzed RSA 91A32, the exception, that is, the hiring exception, was an error. Thus, we declined to hold that the hiring of a public employee includes the employment of an interim sheriff. Notwithstanding the error of the convention to the exception, the lack of minutes for non-public session calls into question the matters of the session. The minutes of June 11, 2007 evidence of the convention's paring down of the candidates without the accountability of the counties of the convention to the public due to the lack of detail. Further, they did not memorialize the discussions with candidates. Neither the law nor the statute offered little guidance to the level of memorialization. The lack of guidance as well as the lack of memorialization is problematic to you as well as to the public. However, the convention did not challenge the trial court, Justice Moll's ruling of the impropriety of entering non-public session in May 29th and June 11, 2007. I believe it is significant that the Supreme Court chose not to invalidate the appointment at that point, given that we need not address the consequences of the convention's failure. The concentration of the Supreme Court's opinion appears to be on the convention's participation in a secret ballot in public session in contravention of its statutory construct, and as a result, the process was fatally flawed. Such public scrutiny is of even greater importance when the public body at issue consists of people who, by their very nature, represent the will of the people, and in this action are substitution of their judgment for that of the people. I believe that the convention has complied in rectifying the flawed portion of the process to the degree that it can. I believe further that the convention's proceeding to deliberation and voting public session by individual claim to appoint one of the candidates to fill the unexpired term is in keeping with the order of the court as well as to the authority of RSA 66191. However, the choice in proceeding is entirely yours. I leave the final choice to you, signed Jim Carroll. John?
Thank you, Mr. Chairman. The Representative Tilton, you are correct in the fact that the law defines what process, but it still does not make a decision. Is it an elected position or is it an appointment of an unexpired term? And I think that that's where the whole crux of the matter, in my view, lies, is which is it? Is it an elected position? Therefore, do we have no right to usurp the constitutional authority of the electorate, if you will? And if it's a appointed process, we can appoint, giving that person all the respect, the private person, all the respect of employees, which they have under the laws. I think that the laws have to be straightened out. I think that if we are going to try to handle this process tonight, I think that, in my opinion, what we should probably do is allow the sheriff's #1 person, the lieutenant, take on the position of sheriff on a decision-making basis. However, in that point, I think that we should also avail ourselves in the county of the professionalism and the experience that we have with the sheriff. And if we terminate the sheriff at this point, or he is terminated, whatever the decision be, that we keep him as a consultant at whatever expired pay that we should have. That's all that was.
Well, yeah, I gotta say, I disagree with that.
I do too, but I would suggest that is one solution.
Representative Aston.
First, I want to say that although I objected to the process and I abstained from voting, I fully agree with the decision that the convention made that Craig Wiggin was, the person that I most wanted to see in the position of sheriff. I feel bad that the process as it was carried out, and I believe everybody under the best intentions, believing that they were doing what they felt was okay, has put a shadow over Mr. Wiggins' appointment or selection or whatever word you choose to use for it. And while I'm very concerned about, you know, what happens in the sheriff's office if, you know, we take more time than this evening, I think that the most fair thing that we could do for the sheriff or for Craig Wiggin is to review the process in the way that we laid it out, to do it openly. Now, I believe even when we were behind closed doors and when, I believe that everybody acted in good faith and made the decision based on, you know, people's qualifications and the best interests of the community. But the community has no way of knowing that. If we were to just go ahead and to appoint Mr. Wiggin this evening with an open vote, and I would certainly support him, that would be based on the process we went through that the public has no real knowledge of. And I just think that that causes a shadow that has, you know, it has nothing to do with Mr. Wiggins' qualifications. So I really do agree, while I hate to delay anything, and I would really rather not create another meeting in my near future, I really think that Representative Morrison and Representative Wood are correct in their thought that we should redo the process. And, you know, and I have every faith that Mr. Wiggin will still, you know, probably rise to the top of that process. And I hope that in no way that any objection I've had along the way had anything to do with any of you. I know that you all believe firmly that you were doing the right thing and for the right reasons, but I think that the court's decision is pretty clear that we weren't right in how we did it. And it's not fair to the public. So anyway, that's just my...
Could I just say one thing? I guess if it was up to me, what I would do is I would appoint Craig Wiggin to become sheriff again this evening. We have in our packets, we have letters, or a letter from the 10 or 11, forget now how many there are, but 11 or 12 individuals who are chiefs of police, the county attorney, and a correctional facility administrator. And they're all supporting Craig Wiggin. No, just a second. Because I think this is important. 3 of the people in that letter were 3 of the candidates. I mean, how now do you call those people back in and say, we're going to run the process all over again? You weren't chosen. Just let me finish up, please. You weren't chosen, so now we're going to ask you to come back and go through the process again. And deep down in your heart, you know, I've already given a letter of support for Craig Wiggin. How now are they even going to listen to me? I find a problem with
Can I
it.
respond to just that?
Absolutely.
One point? I believe it would be, as Representative Morrison suggested, we would post the position, those who wish to resubmit, or even perhaps some of you have not submitted. I would assume that those people that wrote in support of Mr. Wiggins would not reapply because they are apparently pleased with his position and the job that he's doing. So it wouldn't be the same, at least in my opinion, it wouldn't be the same 10 people. It might be that nobody would choose to put their name in, and that would, you know, we'd have to see how that went. But I think you have to just open the process up again and see what the result is and deal with it publicly as we go through.
Representative and then Representative.
First, I want to start by saying that, as you recall, the night that we were talking about the process, Representative Arsenault spoke about the right to know law. I sat beside her, having served the years that I did on the school board. I will tell you, the school board has no right to know, like practically no other entity there is out there, because they're constantly being watched by parents, teachers, and the press, and so forth. And I knew she was right. But I also knew that you thought she was wrong, and I wanted to vote, and I wrote a letter of apology saying that I shouldn't. I really shouldn't. So when that clears us all, I should really agree. I voted knowing I was wrong. And I apologize so much to Craig Wiggin that we put you through this. And it is incredibly difficult. But the one thing I think we have to keep upmost in our mind is that we have to do it properly this time. There can be no cloud. And I think that we owe it to the people who elected us to do it as open a fashion as we can. And I know how difficult that is, and it's our fault. It's not the fault of the sheriff. And I'm sorry. I am truly sorry. I should have tried harder. And I didn't. So, if it were up to me, I think we need to start over. I think we need to advertise it again, and I think it could well be that Fred Wigan is the only one who will apply, but we will have given it our absolute best shot. Otherwise, we're going to be operating under request.
Representative Ann.
Thank you, Mr. Chair. I have a question. If we do not appoint or nominate or elect or fill the sheriff's position this evening, who would be the temporary sheriff, and how would we appoint or fill that position?
The person that is in charge of the sheriff's office right now is the lieutenant, and he would still be the lieutenant.
So, may I?
Sir.
So we would have a lieutenant acting sheriff without a sheriff. Is that correct?
I believe so.
And my only other point, I guess, would be that we have an election coming up in a matter of a couple of months. So to go through this process.
Is somebody over here? John.
The process that the solution that I talked about was the lieutenant taking over. There's been some question that I heard as to what happens to Craig as a sheriff who loses his salary and stuff like that. And that is why I suggested that we decide to do that. We continue with Craig on a consultant basis to maintain the salary level
Can't do it.
at what you would have collected during that period.
Representative, we can't do that. Representative.
I just get a point of information. What is Sheriff Wigan's position as of right now vis-a-vis his financial situation? What is he?
Right now, he gets nothing.
Right now, he gets nothing. What I'm concerned about is what he's gotten, what the status of what he has already received.
Are you suggesting that we ask Craig for a check?
No, I'm asking what is the status? I'm trying to find out what that status happens to be at the present time. In other words, do we have any legal authority to make a decision in one way or the other? I mean, I don't know where we're at. That's why I'm asking the question. Well, it's relevant from the point of view of whether we should be thinking about how rapidly we should correct the situation, if it needs correcting. I mean, this is a man that is sitting in purgatory right at the present time, and I don't think that's very fair to him. And the longer we do that, the longer he sits in purgatory. And I think that we've got to give consideration to his situation.
I think I understand what you're trying to do, but I don't think we can make that determination right now. What we're trying to do is to either make a decision to appoint him again tonight, or start the whole project all over again.
I understand that.
The monitoring part of it doesn't take effect until he is. Right now, he's nothing. Well, excuse me, you're saying. That's nothing to do with county government right now.
Yeah, but let's say, you know, hypothetically, we decided to take a vote and elect him tonight. What, fill the vacancy.
Yeah.
As regards his financial situation, what does that mean? I mean, does he get started, is his actual starting date of getting paid at the point of time that we actually
I would say if we appoint him tonight, he gets that paid.
Right, but what happens to
That's a
the,
different question.
but it sure is one thing that's important to him.
Yeah. Representative Hill.
I think Representative Arsenal's comments were very good and settling. However, I think for us to go back through the process is not going to make the appearance look better at this point. I think it would be a charade. We would be asking people to come back who we've already interviewed, voted down. I've already heard enough votes at the table tonight to say that we're pretty much in favor of, however we get there, to having Sheriff Wiggins resume his duty. So I think it's up to us to get on with it. I also want to point out, a situation a year down the road. Last year, we were looking at an 18-month vacancy. We had somebody that was going to fill. I know we asked the two folks who interviewed in the public session, do you realize that you're going to have to apply for re-election? You're going to have to declare and run for re-election. And the real election that you'll encounter will be November of 2008. Well, through no design of our own, Secretary of State had a solicitation for the job. From the June 4th to 13th, we had people who wanted the job had the opportunity to file. There was one candidate in either party, Sheriff Wiggins. So were we to appoint somebody else, fill a vacancy with somebody else, that person would be reduced to write-in campaign or would have no opportunity, whereas Craig Wiggins is the only known candidate. So I think we're much more consistent with what we did in 2006 in the county attorney's office. And I checked the minutes, I've got them here. Jim Pilliott recommended that we fill a vacancy in the county attorney's office for the 2.5 months until the election by naming Wayne Poole. And that was approved by a 17-to-1 vote, public session. No other nominations. We were able to fill that short term. And part of our responsibility to the public is to do things timely. We're being accused of not being timely in a lot of things. Well, let's not drag it on another month to get to the same solution that I hear everybody is in favor of.
I think that, and I appreciate everything that everybody has said, validity in all of it. I think that the delegation didn't use the process right. I think it's important to note that the Supreme Court really only focused on the secret ballot as the problem. And I think that under RSA 661:9(1), we have to fill the vacancy. And we can't really rewind the tape back to a year ago, a year plus. And we have to go from this point, and as Representative Tilton has said, we don't have to seek applications to fill this position. We can do it as what we're doing right now in the process. We have to do it in public, and we have to do it with a public vote. But I think I agree with Attorney Terrell on his assessment of the process as we are doing it today. You can't go back and replicate a year ago. I thought it would be nice to contact all the candidates from a year ago until I really realized that their lives have gone on. And in some sense, it's not even fair to be put in a position to do that. So I just feel we have the authority to fill the position. We don't, the process isn't, we don't have to look for a pool of people. We have it in the past with the county attorney. That's my opinion.
Representative Morris.
Thank you very much. I wanted to say before we get too much further along that the Supreme Court has answered the question that was posed by Representatives and say that it's an appointment to them. that the confidentiality that a person in such a position.
We can't hear her. Speak up, please.
What I'm saying was that the Supreme Court has answered the question that Representative Thomas has posed, and that the level of confidentiality that applies to an appointment of a person to an elected position is the confidentiality that a person running for an elected position would expect. And that isn't a lot. So it isn't the same situation as a person seeking employment at all. However, they have given us the option of looking over those documents that were sent in and deciding what needed to be redacted. If there is information in there that would require it be treated confidentially, we can remove that and not offer it to the public. The other thing I would like to say is, one of the things that Attorney Carroll said was we have an option of treating the process, treating this as a new day. If we were to do that, we wouldn't be calling the people who applied before back. We would be opening the process again, and 1, 2, 3, whoever, we might even get another application altogether. But I think that is what the Supreme Court is asking us to do. That is what I see. My humble opinion is that the Supreme Court is suggesting in its detailed discussion in Section 1 of the ballot situation and in Section 2 of this decision of how we treated the information. It is saying that we need to be forthcoming with that information because the right to know law requires that it be available to you unless there is a very good defensible reason that it not be available to you. And it's on, the obligation is on those withholding the information to make sure that it meets muster. And so I would favor that we go forward and would move that we go forward with the process that we had set down, but in a very, very open way and as quickly as we can possibly do it, and yet meet the requirements of the law. We do not have a sheriff now. And I would second what Representative Arsenault said about, and Representative Reaver said about the effects, the sorry situation we are in the treatment of former, perhaps, of Craig Wiggin. Thank you.
Anybody else?
That was a motion.
I will second her motion.
What was the motion?
That we proceed with the process that we had adopted, but that we do it in a completely open fashion, and that we do it with all expedience while meeting the letter of the law.
Okay, there was a second. Motion's been made and seconded. For now, we'll open it up for discussion.
Yeah, thank you very much. In regard to the concept of a new day, truly, we are at a very new day this evening. And that new day is so new that when we talk about process, in terms of assumptions that we made about process then, we surely can't make the same assumptions about the process that we made then now, because circumstances have changed substantially. I mean, we are very clear as to what we must do in terms of moving ahead, but in terms of what exactly the process is, that's really our decision. A new day says that's our decision. So if it were the same process, maybe, but it could be a different process also. Now, also looking at it from a new day perspective and looking at the circumstances being entirely different, especially since we have a situation where we have one person who is actually signed up, and then the time has passed now in terms of other people signing up for the elective office of sheriff. Okay, that's a circumstance that's brand new. That's not last week, no. This week, yes. Now we have a situation where, as a matter of practical fact, unless some, I don't know what could happen. Anything I suppose could happen, but the strongest likelihood is that Craig Wiggins will be in that position. And I don't see that if we have a process could be a simple matter of a motion being made as to electing Craig Wiggins tonight. That's a process, and it's a new process. Appointing, filling, whatever you like, but that's a new process, okay? And it is a new day. And it also solves the problem of not leaving Craig Wiggins in a position where he has to go through essentially what I would call the old process being repeated. Can't be repeated. So it would be something on the charade, since it can't be repeated. It would just be a process, a matter of going through motions. And we all know that. So we don't have to repeat the same process, since we are starting brand new, and that process can be very simple and accomplished very easily this evening.
Anybody? Lori?
I believe that we should take a recommendation by the attorney on the first 3 items. Then the vacancy is expiration tonight.
Well, we already have a motion on the floor.
That's discussion.
Could I ask for clarification of the motion, because I think Representative Clark just nailed it head, to say we're going to repeat the process, but we've got to have that defined for us, all the steps of it, because it was detailed. And if we vote on it, are we going to lock ourselves into more detail than we want?
Would you be willing to, can you state the motion, David?
I'll tell you what I put down, and you can correct me if I'm wrong. Motion by Morrison and seconded by Weaver to start the process over again with a total opening.
So what is the process?
So we'll be advertising, interviewing.
Yeah, advertising, interviewing.
Well, that should be defined before we vote, not after.
Well, if you'd like,
Please.
I'm looking at the appointment procedure.
That's not one from last year.
June 13th, 2008. Publicly declare a vacancy. Someone else has done that for us. Notice in the newspaper of a countywide circulation for applicants. Publicly interview all applicants. Publicly deliberate and nominate. Publicly vote on the appointment would be the process.
So that would be your 4-step process.
That would be the process. That would be a repeating of the process that we have used, only in an open fashion.
You got that now, David?
No, or is it in any?
That's a comment from a private letter. That's not the process we use. That's a new process. A letter from private citizens.
Yeah.
That's not the process we use. The process
No, but the process that she is suggesting is that process.
Okay.
So that's her motion.
Well, I'll point out that there was a, in the work group that Representative Millam chaired, there was a process discussed. I think that's probably.
Yeah. It's the process that Representative Morris suggested. Is everybody represented?
I just would like to say, and I'd like this all to be handled as quickly as possible, and the last thing I want to do is to slow things down. But I think that we need to look past the mistakes that we've made and to look at, maybe what seems expedient right now is going to land us back to the court, and it's going to make things more complicated, and we're going to find ourselves sitting here trying to fix things. I mean, I understand that we all believe that what we're saying in this moment, much like in previous moments with this convention, is that we're correctly interpreting what the Supreme Court's saying, or that Jimmy Carroll is correctly interpreting what we can do. But I just think that to be absolutely certain that we don't find ourselves in more court costs, more challenges, and walk out of the term and then find out 2 weeks from now, or a month from now, or sometime in the next 4 months before the election is held, that we're back here trying to figure out how do we fix this.
Yeah, we've been told that we've done things wrong, and we have admitted that.
No, and I'm not,
No.
I'm just saying I don't want to do something wrong tonight
Yeah,
again.
and what I'm saying is we are trying to correct the things that we have done wrong. And certainly by having this meeting tonight is one avenue that we're taking to try to make sure we're doing things right. That's why we're all elected.
No, and what I'm saying is that I think we have to be very careful that the remedy we select is going to be unassailable. That it's not going to be open to interpretation yet again.
Yeah, there's a couple of lawyers here in the group,
That we can
and they will tell you that they can sue anybody for anything at any time. And that's why they get rich. Right away. Representative Russell.
Yes, if I may have follow up Morrison. I was trying to put an addendum to the motion that I've written. Tell me if there's something else I need to include. Representative Morrison's motion was to include advertising, interviewing, references, discussions, and elimination process. Is there anything else?
That sounds somewhat different from what I had suggested. I'll take that away. I would like to say that if we do go forward with the second time, so that, and strictly here, I had said, and I don't care the source, actually, this is what I recall, declare a vacancy, which we've already done. And the Supreme Court has declared a vacancy. Issue notice in the newspaper of county rights. Publicly interview all applicants, deliberate and nominate, and then publicly vote on the appointee. And I suppose
Yeah, not the notices and everything. So you have them 1 a week. Any further discussion? David, I hate to ask you to do this, but would you read the motion back?
Well, I'm going to read it the way I finally found that portion, and I did cover it, although a little bit different language. I've just added what we do again. Representative Morrison's motion is to include advertising, interviewing, references, discussion, and elimination process, and adhere to a strict timeline with a public vote on the appointee.
that doesn't sound like what I said.
Well, I couldn't keep up with it.
Okay.
I can take it verbatim out of
Why don't you just take 1, 2, 3, and
Well, this is.
Well, I didn't say it
this is-
exactly as it's printed out here either.
We're gonna start again.
Place a notice in a newspaper of countywide circulation seeking applicants.
Again, to take a vote and see if you think that it would be a good idea to form a committee just so that we can take 4 or 5 of us and take a look and see if everything is being handled as far as satisfaction.
Anybody else?
Anybody wants to?
Anybody else on the delegation? I guess I would just reply a little bit to the representative's inquiry about why we have a accounting report or budget analysis or whatever.
Or an audit.
Or an audit. I guess you have to live in a vacuum not to realize there's a problem going on here. Okay? When you get your audit back, you get your reports back. And that's what we're working on now. We finally have our reports. Now, well, we're just waiting to get the audit back. Once that comes back, then everything hopefully will set in place. But there are, and you've got to know there's problems here.
Right.
I would
I was concerned.
Well, you know, nobody knows because we don't know. Okay?
But
This is
you
something,
know what you know, and I didn't even know that.
you didn't know that I know?
I didn't know that we lost. I didn't know any of stuff. I don't know why we lost our administrator. I don't know any of that.
Yeah.
And I'm a member of this convention.
And it hasn't been made public yet either.
I know that there are people sitting here that know more about it than I do.
Obviously, because I just sent it to you. Any other business? Sheriff Wigan, and it's an honor to call you Sheriff again.
Thank you for correcting this issue. I think we should have done correctly the first time. I wasn't going to say anything tonight other than say thank you. But I do want to correct something that Mr. Tata says, because he's suggested something twice that I should have said. Once was on the 13th on the newspaper, and he suggested that the honorable thing for me to do would have been to tell these people how to conduct their business. I just want to point out for the record that I was one of 7 applicants for this position. I didn't set the rules, they're their rules. I simply followed the process as it was laid out to me, okay? Well, you question my honor, Tom, okay? That I should have done the honorable thing by telling these people how to run their process and appoint a sheriff. That's not my job, okay? If you don't like the way they're doing their job, you and everybody else in this room as a registered voter can reflect that when we go to the polls, okay? That's the only way I can tell these people what to do, number one. Number two, when this process started, I'll reiterate something that you said again tonight. I had no issues about confidentiality. I'm proud of my record. I'm proud of my credentials. I'll stand on those any day. I had no questions or quarrels whatsoever with that information being released to the public. If anybody wants a copy of my resume, I'll be more than happy to photocopy it to anybody. Anybody that walks in my office and wants to know what my education and my experience level is, I'm more than happy to provide that. Nobody's done that. I'm an open book, I have nothing to hide. I just want that on the record, and that was the only thing that I wanted to say tonight because it's been brought up a couple of times. Thank you, Mr. Chairman.
If I may, my name's Robert Henderson. I'm an employee of the Sheriff's Department. I'm also a taxpayer and resident of Belknap County. And I think you people have done yourselves proud tonight. You sit here, you did what you did what you were told was right to do by the county attorney. And so far as the people go, just remember, the people in the county put you here. They put you in a position of authority and responsibility. They trust you with what you're doing, and I think you're doing a fine job, and I, for one, thank you for putting Craig Wigan back where he belongs.
Do we have a name, please?
Robert Henderson.
Thank you.
Anybody else want to go first?
Thank you, Mr. Chairman. Doug Lambert. I'm not here to speak on the sheriff issue. I'm here to speak on the second big issue that has really been nagging at me, and I wish it wouldn't all happen at the same time because it gives the illusion that we have a stop. And The problem is that the county has a lot of issues, as Representative Rossino said. This book just was released. Apparently they came in yesterday. I got mine today. By law, this book had to have been finished by March 30th, 2008. I have emails and correspondence telling me that the reason this book is not finished, or was not finished, was because the audits weren't ready. Last week, I found out that the audit was supposedly ready and the books were off to the printer. I get my book today, and would you believe, the audit's not in here. For 86 days, we have been told that this book was held up because of a lack of an audit. Now, the law very plainly says that this has to be done. And anybody that violates it, and it's all the department heads of the county, have to file their annual report by the end of March, not June 25th. Now, I think that the department heads have been run out to dry by the county commissioners. I would imagine, although I do not know, because since April 17th, there is an open right to know law request that has gone unfulfilled. It was all printed in the paper yesterday, where the addendum to yesterday is the fact I got this book today. And everybody saw the emails, and it was plainly said to us that this book was held up because of the audits and the lack of that being complete. The book is out, and there's still no audits in it. The law very plainly says that any person who violates any violation of the ordinance that says this has to be done, the annual reports of the various department heads, any violation of any part shall pay a fine to the treasurer. And the fine is in the law as well, $5 per day per violation. And what the county commissioners have done is hung out our department heads, because their reports were not made available to the public until June 26, 2008, 86 days after the law says they shall be completed. Now, there are ongoing right to know law issues. We come in here, we were told yesterday, come get all the documents, they weren't all there. We were told that's all we have. Today there were more. There's signs in the lobby, be green, live green, save energy. I had to drive here twice in a gas guzzling truck to come pick up documents that were supposed to have been made available. There are serious problems in this county. I believe nobody has bothered to go to the RSAs, which, you know, somebody said there are some people that know more about this than others. I would say that you've got some citizens that know how to use the internet and go look at these on a regular basis. There's ones that say counties, commissioners, convention, and you just go through and you highlight and you see all the dates. And that's what you must do. It's not small things or just little things. We've got other bigger business to take care of. All these items that are required of the county and the various departments all provide, at the end of the day, for openness for the public to know what their government is doing. Okay? The county commissioners, and again, this is separate from the sheriff, that was before. The county commissioners, through the budget process, the bonding process, okay, through all these different things, have dropped the ball. And obviously, if there's a Supreme Court judgment, and everybody's talking about it like it almost doesn't exist, I don't know at what point do my elected officials care about the laws that they have to live by. You can make laws to put me in jail. You people can put me in jail, basically, with the law. And the law also provides what you people or the government must do. And at every turn, the government isn't following the law. And I really would like to see a motion made tonight to see that committee, as the law provides, and take a look and find out who is responsible. Because nobody's going to learn. It's a $5 per day charge that is owed to the treasurer. Because this, and really, you ought to ask somebody, how could it be after 86 days that we're told that there was no audit available that was holding up this book?
Excuse me just a second. Craig? Will you be coming back?
Yes.
Okay. Sorry.
I'm distressed about that. And of course, the investigation part of the law, she didn't really read the law itself. It talks about investigating. Everything that's so far unavailable has everything to do with the problem that we've got. Now, you've also got other problems where you've got a commissioner in your office that was supposed to oversee the person that has the problem. He's in the office. Maybe the problem was his lack of oversight.
Oh, okay.
Okay? I would really like to see
Let's
an
cut this.
investigation.
Okay.
You guys,
That's enough. Any
Thank
other
you.
business? If not, I'd entertain a motion. Motion been made and seconded that we adjourn. All those in favor signify by saying aye.
Aye.
We're closed. Is there any on July 7th? Commissioners' office? What was the commissioners' office? Last Hold on just a second. This is a little longer than